Make sure to like, follow, and subscribe wherever you guys get your podcasts.
Listen, do what you gotta do to keep us real, okay? Welcome to episode 6 of Off the Cuff. I'm Matt Butler.
I'm Darren Chohan.
We'd like to thank everybody who checked out episode 5, where we closed the gate on neighbor
really?
disputes.
Okay, I'll give you that one. That was good. Yeah, it was good.
I'm a funny guy. We're joined in today's podcast with a special guest, an associate with Weaver Simmons, and her name is Marissa Sarrazin. Thank you for joining us today.
Thanks for having me.
Marissa, why don't you tell us a bit about your practice?
Well, I'm a wills and estate lawyer as well as real estate, and you can imagine how busy we've been this past year.
It's been good for you this year.
It's been a pretty good market.
So many real estate transactions, so many people wanting to redo their wills. It's been hectic at our office.
Good stuff.
COVID, I guess.
COVID, yeah.
And the real estate market's been pretty crazy.
Pretty good. Don't buy a house.
So, Darren, what are we talking about today?
Well, we got some feedback from our listeners, and as Marissa said, everyone wants to hear about wills.
So, Marissa, what's a will?
It's a very good question.
Thank you.
You know what? That's the first thing that our clients normally ask us. And what a will is, it's a legal document that writes down what is to happen to someone's belongings after they pass away. It's often known as a last will and testament, and it will detail exactly what's to happen to your house, your money, who's going to get your belongings after you pass away. And it's often something where viewers and clients don't think they need, which is an interesting point of view. A lot of times people will say, why do I need a will? And at the end of the day, it's because it's going to allow you to decide what is to happen to your belongings, and that's the way it's going to be.
Probably because I would think it's an uncomfortable conversation.
I think it's incredibly uncomfortable to have.
And that's probably why people don't, I think it's just one of those things in life where you just avoid doing.
I think so. Have you seen that in your practice?
We see it all the time.
Yeah.
That's something you want to plan. You don't want to plan for your death. It's difficult conversations. And at the end of the day, what we try to do in our meetings is to make the person comfortable and start off with easy questions, such as their name, their date of birth, what they do for a living. And then we really get into, all the assets that they own. And then afterwards, once we've done that, we'll ask them some serious questions, like who's going to be your executor? Who's going to be your beneficiaries? And when I say beneficiaries, these are the people who are receiving the estate. And when I say estate, that's all the goods, all the money, all the real estate that's owned by the person after they pass away.
So that sounds pretty overwhelming.
Yeah.
Do you help your clients beforehand to get ready for this meeting, or how does that work?
Yeah, is their first introduction to this in the first meeting with you?
It really isn't. So
well, that's good then.
A lot of the individuals will either contact us by email or by phone. And when we schedule our initial meeting, we're asking them a series of questions so they're prepared at the actual meeting.
Okay.
So some of those questions are, hey, can you bring us a list of what you own so we can talk about that in detail? Mm-hmm. If you have a previous will, please bring it so we can review it to make sure that we understand what the person's wishes are and what the changes they want to do, if there is any changes to be made. And a lot of the times, you'll see individuals that have wills that were made by a famous Staples will kit. So we want to make sure that, first off, it's a legal document. Most of the time, it's not. So that's why they're coming to our office, just to confirm that and actually draft the valid document to protect their interests. And then
you see a lot of that?
We do.
Yeah.
We do. And that's what we're here to help. We're here to show them how to draft a proper will and make sure that their wishes are respected. And at the end of the day, we know it's going to be a valid document.
It's pretty intense.
Yeah, I think it just goes back to it's an uncomfortable conversation, and people are worried about spending money on things that they don't think they need. And that's where I think that makes sense. You see these Staples wills, as you call them, or the internet will. Mm-hmm. And I think it's important for our listeners to know that it is important to get your interest protected. And I think that after hearing what you do, it makes it even more important to go see a lawyer and get your affairs in order, because anything can happen, I suppose.
Yeah. And when they come to do a will, do they often get a power of attorney done as well?
They do.
And what is a power of attorney?
So a power of attorney, there's actually two of them. So I'm going to kind of describe what both of them are. So there's the power of attorney for personal care. So this document is going to deal with any healthcare decisions that are to be made, perhaps homing someone in a residential complex after they're incapable of living on their own. And then there's the power of attorney for property that deals with finances, making sure bills get paid. This power of attorney actually gives the ability to sell real estate. But it's very important to know that powers of attorney that we draft at our office only kick in when the person's incapable. Meaning if Joe and Lisa come to our office tomorrow and want to have powers of attorney and sign those powers of attorney, it doesn't mean that the individual they're naming in the document becomes valid at that time. They would actually have to wait until they're deemed to be incapable, which oftentimes reassures clients because they don't want necessarily that person to be doing the banking for them at this present time because they are fully capable and can do so on their own.
Right. That's probably a common misconception where someone says, well, I'm power of attorney, so I have the right to do this.
Correct.
So it's only triggered when someone's deemed incapable.
Exactly. The ones that we draft at our office. There is the ability to draft a power of attorney for property with the notation that it would kick in at that present moment if that's your intention. So we often see these for individuals that are perhaps out of the country or in custody. They can't exactly pay bills from that facility. So the power of attorney would assist them. Now, another thing, which is a common misconception that we see often, is that powers of attorney are still valid after someone passes away.
Right.
So the minute you pass away, your power of attorney is not valid. So if someone comes to our office and says, unfortunately, my father passed away, I was the power of attorney, what do I need to do? You technically don't need to do anything.
Right.
You're no longer acting on that power of attorney. It would have to be who the executor in your will is.
That must be something that happens quite often then. Someone coming in, well, I'm power of attorney, so let's deal with their estate. And you're like, no, we need to see the will first.
No, exactly. And we're thankful they called us because some of the times they don't know the difference.
Right.
So that's what we're here to do, is to assist them in knowing the difference between the power of attorney and the wills. And we oftentimes want to elaborate on that with the clients as well, so they're aware.
That's really interesting. I didn't know that a power of attorney just goes away immediately on death.
It makes sense, though.
It does make sense because then the will would kick in. I did have a question about editing a will. And so if a client comes to you, let's say we're not talking about the internet will because the internet will has its own problems, obviously. But I'm more interested in, this person has had a will drafted 20 years ago. It's obviously circumstances have changed and they're coming to see you. So what is your recommendation when somebody comes to see you with an existing will that's valid in theory, drafted by another lawyer, for example? What happens?
There's a couple ways we can actually proceed. So the first way is to create a document that's called a codicil. So what a codicil is an additional document that goes and works with your current will that will change a specific clause in the will. So for example, if my current executor is John and I no longer want John to be my executor, but I'd rather have Lisa, we would actually create the codicil that says, I revoke this paragraph and substitute with the following that says, I want my executor to now be Lisa.
Practically speaking, is that just like a piece of paper that slides in?
Correct.
Okay.
Exactly.
So you're not actually scratching anything out on
We're not. So actually, if you were to scratch off something on the will, you'd technically be invalidating it. And the reason I say that is because when you sign a will, you have two formal witnesses that are witnessing you sign that document. They won't be the same if you're coming to a different lawyer's office and you're trying to make changes. So what we would recommend in that case is to do the codicil, and that way you can technically change without scratching it off on the actual document.
Right. Okay.
And then the other method?
So the other method would be to start from scratch and create a new will. So what we would need to do for that purpose is to actually ask the questions about the assets once again, and we would redraft it the way that we do here at our office and make sure that it clarifies and respects the new wishes of the testator.
So you're revoking the pre-existing will?
Correct. So if I were to sign the new will, it will revoke the old will that was previously made by that person.
Oh, that's interesting. So a codicil would very likely be used in events where they're very minor changes. Is that correct to say?
Correct. And it works in conjunction with the current will, so it won't revoke that document. So you're right in saying that normally when we draft codicils, the quick fix is just changing an executor because perhaps that person's passed away or they're no longer in contact with that person. But if it's substantial changes, such as what's to happen to your real estate when you pass away, or you actually want to change your beneficiaries completely, meaning the people who are going to receive the money when you pass away, then it's recommended that we start from scratch and just do a new will. Because oftentimes we get calls from clients that say, hey, mom's passed away, I have a codicil. Well, that's fine and dandy, but we don't have the whole picture. We don't know what the actual will indicates. We just have the changes to the will. And we notice because they're done at different times, they're not necessarily put together in the same envelope. So it gets a little bit tricky whenever we're dealing with codicils, because we want to make sure that the client knows the codicil is just something that works in conjunction with the will and not a separate document itself.
That brings me to another thought I was thinking about while you were talking. Where do the wills get stored? Who keeps them?
Yeah.
So
That's a great question.
That is a very good question. So certain law offices actually keep the wills in vaults.
Okay.
So you have the option to do so. Here at our office, we actually recommend that you have the original with you. So once you finish your meeting with us, you'll sign your will, perhaps your powers of attorney as well. We'll give you 2 envelopes, one envelope that has the originals in it, and it's clear as day. They're in a nice sleeve, blue ink, whereas the copies are going to be in a separate envelope with the stamped copy. We found this is a lot easier to give the individual their will in the event that, God forbid, something happens on the weekend, or perhaps this individual no longer resides in town. It is quite difficult to locate that will. And especially for powers of attorney, we all know it's not necessarily a perfect world where if you fall sick, it's going to be during the business hours of 9 and 5. So if, God forbid, something happens to you and you need a power of attorney for mom and our office is closed, we really don't have an access to it. Yeah. So we provide the originals to the clients now.
And I think, talking about those powers of attorneys that we were talking about earlier, and you had mentioned capacity and when somebody loses capacity, I think it's about time we can take a break. We'll hear from our sponsor, and we'll hear about capacity afterwards.
Sounds good.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
So, Marissa, I don't have a will.
Actually?
No.
Good job.
Will you help?
Yes.
What do I first need to think about when planning on getting a will?
Well, what do you own?
I'd rather not say.
Okay. Well, a good thing to think about if you're planning on drafting a will is you need to determine, what do you own?
Right.
Do you have a bank account? Do you have RSPs, TFSAs?
Do you have a dog?
Life insurance. A dog. That's a good point. Real estate.
This is going to be good.
These are all things you should think about. And at the end of the day, we will discuss those with you on your first meeting as well to make sure we know how to properly deal with them in your will. So number 1 thing, make sure you know what you own. Number 2 thing, who is going to be your executor? And
what's an executor?
When I say executor, this is the person that is responsible for following what's written in your will.
Okay.
So this person has a lot of responsibility, and oftentimes it's seen more as a burden than a gift.
Do you tell your clients to get permission from the executor first, or
who can be an
you know what I mean, right? Like, is this something where obviously I don't think they need permission, right?
That's correct. They don't.
So it could be a top secret executor assignment. Never a good thing, probably.
Well, yeah.
But do you recommend that they have these conversations with the proposed executor before they actually come to see you to put their names on the paper?
I think it's a great idea. And if not, before they meet with us, after the document is signed. But at the end of the day, what we actually see is 2 extremes. There's some individuals that are completely private. They don't want anybody knowing what's in their will. They don't want to tell the person they're going to be the executor. And then there's the individuals that actually have the conversation months before they draft that document.
Ooh.
I think it's a great idea because at the end of the day, you want to make sure that they know what your assets are.
I don't know if I would like to be an executor of somebody's will if I didn't even know I was going in there.
Well, the other thing is, can I name whomever to be the executor of my will?
So long as that person has capacity, they're over the age of 18, you certainly can name whoever. And when I say whoever, obviously it needs to be an individual. It can't be, you can't name Canadian Tire or something like that to be your executor. It's often recommended that it's someone that you're close with and someone that knows all your assets as well.
But it doesn't have to be.
Correct. Does not have to be.
That's weird. That doesn't have to be.
Can
you pick anybody?
That doesn't sit well with me. Have the conversation, people.
Yeah, have the conversation.
God.
I think that's
It's
a
an
lot
easy
better.
conversation.
Yeah.
Is it?
You just
Could
tell them
be.
you're going to be the executor when I pass away.
Oh, that being said, can they say no?
Yeah.
Well, it's one of those things where if you do have a conversation with them and they say no, you technically speaking can still put them in the will. But at the time of your passing, if the will says, I appoint Joe as the executor and Joy at that present time does not want to be the executor, he can renounce. And what I mean by renounce is essentially saying, I'm out, I don't want to be the executor. And by doing so, you would actually sign a form to confirm that you're renouncing as your responsibility as the executor. So we often actually recommend our clients put an alternate executor in the event that, the first person is incapable, maybe they don't want to act, or they've passed on themselves. At least you have an alternate that can step in to be your executor.
And I think we're going to get into later on in the episode a little bit about probate, and that might be appropriate at that point to talk about the mechanics of executor appointments. The other question that came to mind is, can two people be an executor at the same time?
They can. And
how does that work?
Yeah, that seems confusing.
You actually have to ask yourself that question. So if you're naming two people in a will, there's two ways you can proceed. So as executor, you could have them acting jointly, which means they need to do everything together. They need to go to the bank together. They need to sign all documentation together. You can also decide if you want to have them jointly and severally, which allows the flexibility, of course, that if one of the executors is not in Sudbury, for example, they can attend the bank, obviously with the consultation of the other executor, but they don't both need to go together. So you have that option and flexibility.
So jointly and severally, just for our listeners, that just means one can act in the absence of the other with consent.
Correct. So together and separate, exactly.
Okay. That makes sense to me.
Okay. That makes sense. So now I've considered my estate. I've considered what to do coming in to a first meeting. I'm going to put my property, my dog, and then think about my executor, maybe talk to somebody about that. Now, I meet you for the first time. I walk into the meeting. What does that first meeting look like?
The first meeting, I would describe it as kind of a two-stage process.
Okay.
The first stage, gathering initial information about that individual, gathering some information about their assets. And once that's complete, we would go into the second stage, which I call the will drafting stage. And that's where you gather the information, such as who's the executor, who's the beneficiaries. And when I keep saying beneficiaries, what I mean by that is the individuals that are receiving money or gifts from the individual after they pass away.
Does it have to be an individual? Can I give some of my assets to organizations?
You definitely can.
Oh, okay.
So we often see that where there's a combination of gifts going to individuals and gifts going to charities as well.
Okay. And that first meeting, so it's basically just an interview process of sorts.
That's correct. And we try to make the individual as comfortable as possible so they understand the process and they know at the end of the day what's going to go into their document.
Who goes to those meetings?
Mm-hmm.
So we often see the actual client come to the meeting, and oftentimes they'll bring a support person with them.
Okay.
Which is great. It assists them in, making sure that they're attending on time.
Right.
And the difficulty with that, however, whenever you're bringing a support person with you, we often get the concern, maybe this person is getting influenced by this individual. So you'll see in our meetings, the initial questions about the person's name, that's fine if the other individual or support person is in there. But the minute I start asking questions about the assets or instructions for the will, I will automatically ask that person to leave the room. And the reason I do that is to make sure that the individual is not relying upon the support person to answer the questions for them, and they don't feel pressured by that person as well. Because oftentimes you'll see some difficult questions such as, who do you want your beneficiary to be? And it's not necessarily going to go to the person that's with them. Mm-hmm. They don't want to insult that person. That person has taken time out of their day to come to the meeting with them.
And does that solo time with that person also help you establish capacity to get instructions for the will?
It really does. So the main thing that we see in these types of meetings is if there's someone there, again, they're relying upon that person to assist them. So if you're meeting with the person one-on-one, you're really getting to determine, does the person appreciate what the will is going to do? Does the person appreciate and understand the value of their assets and what they own? Mm-hmm. And does this person appreciate what would happen if there was a dependent? And when I say dependent, it's an individual that's relying upon this person to, receive something from their estate after their passing. You're really making sure that the person understands those three things. And if not, there's a problem. There's something that we're going to have to figure out how to determine that.
Yeah, so what is the problem then? So if you are to have a conversation with someone and you're going, they don't appreciate, their assets, or they don't frankly know what their assets are, they don't appreciate what the will does, what are sort of your ramifications at that point?
And there's a couple ways you can proceed. What we often see in our field of work is we'll often refer this person to a capacity assessor. So it's a professional that has the ability to assess the capacity of this person by asking them questions and things that can elaborate on their assets. So we often refer to that. And there's sometimes where the person's just having an off day. Mm-hmm. So there'll be times where we'll actually meet with an individual multiple times to determine, was that just a bad day? Maybe at the end of the day, they just really didn't know what their finances were because they weren't prepared for the meeting, and they needed to attend the bank to get statements to know how much money they have in the bank account, what type of bank accounts they are. So it's really one of those things where we're not professionals, we're not capacity assessors in any matter of, we don't have the ability to do that. What we do have the ability is to determine capacity when we're meeting with the client on a professional lawyer basis.
Mm-hmm.
So
right. And so just to flesh that out a little bit, if you're sending somebody, if you're concerned about capacity, so if it's not abundantly clear to you that this person can give you instructions, you either will refer them to a professional capacity assessor, mm-hmm. or you'll attempt to meet with this person over a few meetings to really get a flavor of whether or not they do have capacity.
That's correct.
And the capacity assessor, is that covered by OHIP? Is that something that the person would have to pay for? Do you know?
I'm not entirely sure, but I believe it's a cost that would need to be taken by the individual.
Okay. And do you often work with their healthcare providers at all? Like, would you contact, for example, if they're being followed by a family physician or something, just to get an idea if the family physician has had conversations or has noticed, a decline in their, capacity or their ability to give instructions?
We certainly have in the past, and we've noticed with certain individuals that perhaps had a stroke. The family doctor is the best individual to assess what progress they've made, how they were before, mm-hmm. how they are now. They're very knowledgeable in that field. So we do oftentimes reach out to family physicians to ask them the question, hey, does this person have capacity? We'll either get a yes or a no. There's times where they'll often say, perhaps they should go see a professional capacity assessor. And if that's the case, perfect. We'll certainly recommend that to our client. But we can definitely get the answer from a family physician.
And then at the end of the day, if nobody follows your recommendations, if let's say they don't want to get a capacity assessment, do you decline to draft the will?
It's a case-by-case basis. So there's, again, situations where there might be a day where the person has capacity and the next they don't. So oftentimes prior to determining whether or not I want to assist the client, I will have more than one meeting. But if at the end of the day, after the second meeting, it's still something where I believe that there's a lack of capacity, I will not draft the document for them.
That makes sense. That's got to be really tough. I mean, that sounds like I wouldn't want to be in your shoes. That's a tough thing to be able to assess on the fly.
Yeah, and that's a conversation I wouldn't want to have either.
No, because you're effectively saying, sorry, I can't help you because I don't believe that you have the ability to give me instructions, and
it's very
that would be a
difficult.
tough conversation for sure.
I think this is a good time to take a break.
Yeah. What's next?
What's next? We're going to talk about when we die, what happens then? What happens to our will then?
Probate.
So probate, yeah. So we're going to take a break. We'll come back. We'll discuss probate.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
So Matt's dead.
Excuse me?
What do we do?
Find the will.
You can mourn my death first.
She must practice estates law.
No, serious answer. When clients call us, the first thing that we ask them, where's the will? Do you have the original will? And then we'll confirm whether or not this person is appointed as the executor and has the authority to ask those questions.
At some point, mourn the death. But
I'd like
after
for you guys
that,
to mourn my death. Yes, please. Thank you.
that person that's calling you,
Yep.
presumably is the executor.
Correct?
You hope.
You would hope. There's times where they're not.
Okay.
Well, let's presume in this situation they are, yeah.
But you would verify that somehow, right?
That's correct. Yep.
Okay. And then what happens then? Like, what's the next step for the executor?
So during that phone call, we'll actually prepare them with a list of questions to assist us in determining whether or not they need to apply for probate. So we ask them questions such as, what are the assets at the time of passing? Do you have the original will? And at that point in time, we can say, yes, you need probate, or no, you don't need probate.
So how does the executor obtain this information? Like, do they just have it somewhere that it's available, or is this like a fact-finding exercise for them? Like, what happens?
It's a little bit of both. So you'll see scenarios where the clients that come in, the executor, they're very prepared. They have all the information they require. Some of them actually come with their binders prepared and ready for their meeting.
Oh, those must be the best clients.
Those are great clients for sure. And then you also have the circumstances where the executor might not necessarily know what the assets that individual had at the time of the passing. So we actually assist them with determining that by writing some letters to the banks. Sometimes we inquire whether or not they had a filing cabinet at home that would help them find some of that information. Okay. It's really a case-by-case basis.
And presumably this leads to what you were talking about, the infamous probate.
Yes. And probate, technically, the correct terminology to use is a certificate of appointment of an estate trustee with a will or without a will.
This is why nobody likes lawyers,
That's
man.
so wordy.
But most commonly known as
Correct.
probate.
Probate.
Exactly.
Stick with that.
And what probate is, it's a court process that validates, firstly, that that's the last will and testament of that individual, confirms the executor, and confirms the assets that that individual owned at the time of their death.
And you have to do that?
Yeah, I was going to say, do all wills have to go through probate?
Nope, you don't. So there's circumstances where you actually won't have to do probate. And those are circumstances where they're fairly minimal estates and often under $50,000. The big kicker is real estate. If you own real estate, you most likely will have to apply for probate, and that's because of the large value of money that we see in houses these days. The market is booming. Houses are worth a lot of money. You most likely will need probate at that time.
And what happens, you have these assets, you're applying for probate. Are there fees associated with that, or what? Is there, something that goes on with the court there?
Yes, there's the dreaded probate tax. So once you determine the value of the estate, so all the belongings, you'll have a number to that. You actually have to pay a tax on that amount. First $50,000, no tax. Above that, there is.
Why am I not surprised? We all know the only thing that's guaranteed in life, I guess, eh?
Death and taxes.
Government's going to get their share.
So, along with the probate, there have been changes along with the wills recently in the Succession Law Reform Act. There have been amendments to that piece of legislation. So, what have been the changes with that?
Yeah, so there's been some big changes to the Succession Law Reform Act.
And that's the piece of legislation for the listeners, you guys. Generally speaking, estate stuff is dealt with under the SLRA. It's a primary piece of legislation.
That's correct, and it's an Ontario legislation.
Right.
So we saw some very exciting changes that came into place last year, and the first is virtual signing. So as everyone knows, COVID has come, still here. We've had to modify some things. So prior to COVID, you could not sign remotely a will. You would have to come to the lawyer's office, or the lawyer would actually go to your home and you would have 2 witnesses watch you sign that document. Now, because of COVID and the difficulties of individuals, attending the lawyer's office or attending someone's home, you can do so by way of audio-visual technology. So what that means is in those circumstances, you would actually send the will to the client. Client would review it with you. Once client is ready to sign that document, by way of Zoom, FaceTime, Teams, I would watch the client sign that document with the camera. Both our cameras are on. The client would sign the last page of the will, show the document to the camera to confirm that they signed that document. And once that's complete, they mail back the document to us, and the 2 independent witnesses, when I say us, I mean witnesses, would watch and do the same exact thing. So I would sign the document, show it to the client. Second witness would do the same exact thing. Once that's done, the will is complete. You can also do it by way of counterparts, which is another mode. And essentially what would happen is same context. You would have the will with the client. I would have a copy of the will at my screen or my personal residence or office, wherever I am. Mm-hmm. I would sign that document, show it to the camera. Client would do the same thing. And together they form the valid will. So it's really facilitated a lot of signings for us, especially during COVID. We're even able to reach out to areas that we weren't exactly able to do so in the past.
Right.
So that legislation is here to stay. It's been codified. It's in the Succession Law Reform Act, and it's quite helpful to a lot of lawyers and individuals.
Sounds super helpful.
That sounds very
I guess
user-friendly.
The world is adapting to COVID and virtual signings, and in our practice we see
we see it in our practice.
We see it a lot. We can do affidavits virtually now, so that's always a good thing. Were there any other changes to the SLRA?
There was.
That our listeners would want to know about?
Yes. So one of the major changes that we actually saw recently was that a marriage, depending on the time frame of it, so it has to be after January 1st, 2022, no longer revokes a will, which is huge.
Sounds like an interesting topic.
I think we should expand on that in episode 7.
Yeah, I think our listeners would probably enjoy that, eh?
I think we should talk about that.
Yeah, I'm okay to do that.
Yeah, so episode 7, how about we touch upon those changes, the revoking of the will, it's no longer applicable with a new marriage. We can talk about wills and estates in the context of family law, dying intestate in family law, what does that mean? And then we can talk about common law property rights as well.
You just do that off the cuff?
Yeah, off the cuff. That's the name of our podcast.
That's how we keep you around, I guess, hey?
There you go.
Well, tonight was eye-opening.
Very much so.
We found out a lot about the wills. We found out what probate is. We learned a lot of useful tidbits, I think, that should help our listeners and our viewers, really start to think about estate planning. And we can't stress to you enough, it's never too early to make these plans.
Super important.
And so on that note, I want to thank Marissa for joining us tonight. Thank you very much.
Thank you.
For those of you who've not yet made it to the end of an episode and saw the credits, Marissa is also the voice of our podcast. She is our ad girl. So we thank her for that.
Thank you.
And now you can put a face to the voice. And that's a wrap for tonight. I'm Darren Chohan.
I'm Matt Butler.
See you next time.
Join us next time.
Make sure to like, follow, and subscribe wherever you guys get your podcasts.
Listen, do what you got to do to keep us around. Okay?